Hello guys, this is Olayeni Diekolola Daniels, popularly known as Dieko Spectre, and welcome to another episode of Dieko Talks Law. On today's episode of Dieko Talks Law, we will be talking about the sixth exception to the doctrine of privity of contracts, where we are talking about interference with contractual rights. In my previous set of classes, I have discussed the 5 other exceptions that are exceptions to the doctrine of privity of contracts. In this class, we'll be talking about the 6th exception, which is interference with what? With contractual rights. But before we go into our lecture for today, if this is your first time of coming to my channel, then I want to say a very, very big welcome to you. Thank you so much for making it to my channel. Please do not forget to click the subscribe button and the notification bell so that anytime I release a video of this nature, which is going to be of interest to you, you'll be one of the first set of people to watch that particular video. Also, do not forget to share with your friends and colleagues and those people who you know will be helped greatly by this video. Lastly, do not forget to follow me on LinkedIn at Diekolola Daniels and on Instagram at Dieko_Daniels. Thank you so much as you do so. So in today's class, we are talking about inference with contractual rights, and we go straight to our notes. It should be noted that at common law, it is a legal wrong, that is a tort, for someone to knowingly interfere with the contractual rights of others. Let's start with the case of LUMLEY versus Guy. I will explain the principle while I'm explaining the case. Now, Miss Wagner was an opera singer at LUMLEY's theater on a 3-month contract. Okay, so there is a contract between Mrs. Wagner and a theater. You know, it's just like Wizkid. Wizkid, come and sing at our club for the next 3 months every night, and we are going to pay you 100 million. And then Wizkid is like, okay, no problem. So that's what happened here. So we have Mrs. Wagner, who is an opera singer and is supposed to work at LUMLEY's theater for 3 months. Now, what happened? Guy and Wagner, now Guy is a third party. Now, Guy and Wagner made an agreement that Wagner would break her contract and refuse to sing at LUMLEY's theater. Wagner agreed to sing at Guy's theater only. Wow! But there is a contract with LUMLEY that Wagner was going to stay with LUMLEY, right? And sing at LUMLEY's theater for 3 months. So, Guy, knowing fully well that this contract exists, told Wagner to break that contract and come to his own theater and sing at his own theater for that 3 months, and he should do that to the exclusion of any other theaters, which means that she shouldn't go to LUMLEY's theater at all. Wow. Okay, so what's the issue? Whether LUMLEY had a cause of action against a third party for wrongdoing and whether he was entitled to claim damages. The very important question is, can you sue Guy? The reason it could be said that you can't sue Guy is based on the doctrine of privity. Was Guy a party to the contract between Wagner and LUMLEY? If Guy was not a party between the both of them, was there any contract between LUMLEY and Guy upon which LUMLEY can sue? No, there was not. And then Guy was also not a party to the contract between Wagner and LUMLEY. So the question is, on what exactly would LUMLEY sue Guy? Why can't LUMLEY sue Wagner for breach of contract? Do you understand? Wagner, you said you will come and sing in my theater, and we no see you. Waiting happen. Do you get what happened? Oh, I just feel like not coming. You just feel like not coming. Oh, yeah, pay for damages, and then you will sue her for breach and collect damages. That's Wagner. So why are you suing Guy? Is Guy privy to your contract, or do you have a contract with him? So that is the issue. But what did the court say? Now, Wagner and Guy were joint wrongdoers as they conspired together, causing loss. Now, where a third party interferes either intentionally, Guy in this case, where a third party, Guy, interferes either intentionally and or maliciously with the performance of the contract, they are liable for any loss in the form of damages that arises from the interference, either individually or jointly. Any persuasion used to influence a contracting party to breach their contractual obligation and go towards proving the third party demonstrated an intention to interfere and cause loss. The court held there were two propositions that determined whether a third party could be liable for an actionable tort. Either the person whose persuasion to break the contract was liable, or the action of seducing a person from a contract or persuading a person who has contracted for service was found liable for damages for their interference. Thus, it was deemed that the application was wide enough to encompass the current case where it would apply to an opera singer. In the event that a contract is broken and does result in a loss of some sort, if there was no knowledge of the breach by a third party and no intention to cause loss, they will not be liable to pay damages. LUMLEY did have a cause of action, and Guy, the third party, was required to pay damages. Now, I love what the court did here. Now, the court gave us certain elements. One of it is intention or malice. So when you are looking at this, there must have been an intention. What is the first element to prove? If you are going to prove privity of contract, that the third party is privy to the contract and can be sued based on the contract, you must prove intention. Intention to interfere with the contract, or malice. The person intended to, or the person had malice, and through the malice the person did what the person did. Do you understand that? The second thing is that they must have caused loss to that party in the contract. They must have caused loss to the party. So imagine that Davido was supposed to perform at O2 Arena. Are you listening to me? Davido was supposed to perform at O2 Arena, and then, they have a third party, this promoter, who does not like the other promoter that called Davido to come and perform. Doesn't like him. So he told Davido, no go, no mind them, and all that, and stopped Davido from going. And that obviously, because that other promoter would have, broadcasted that Davido is coming, and everybody bought tickets because they wanted to see Davido. And because of that, everybody started asking for refund, the damaged properties and all that. He had a lot of loss for something that he didn't even do anything wrong. He called Davido, he had a contract with Davido, but Davido just did not come. And then he later saw snaps. Are you listening to me? He saw snaps where that other promoter that is fighting with him was chilling with Davido. And in fact, that promoter was saying in his video, those idiots that say that, they are going to promote blah, blah, blah. They are the best promoters in the world. He's just trying to say malicious things against the person. Now, I'm just giving you an idea of what is going on. So the person can obviously sue Davido for what? For breach of contract, right? No problem. But can the person also sue that other promoter for interfering with Davido coming to fulfill the obligation of his contract? Yes, if there is intention and then there is loss, which is the second element, and also there is what? There is an interference. Three things that the court has told us: intention to interfere, actual interference, and loss of business. Once you can prove those three things, then yes, you can prove privity of contract to a third party in relation to contractual rights. Three things: intention, loss, interference. You must prove those three things. Let us look at the second case of British Motor Trade Association versus Salvador. A bought a car and covenanted with B that he would not resell it for 1 year without first offering it to B. C bought the car from A within the year with notice of the covenant. The court held that he was wrongfully interfering with B's contractual rights. Did you see that? Did you see what we are talking about? So you have A and B said Thank you so much for watching the class to the end. I hope that you enjoy the class. Do not forget to subscribe and like, and also do not forget to follow me on LinkedIn and on Instagram at dearco_Daniels on Instagram, dearcolola Daniels on LinkedIn. Thank you so much. I will see you in my next class.